Stop scrolling. What you're about to hear is one of the most intense courtroom moments I've ever broken down. A mother of three, 4 drunk driving convictions. A judge who has given her chance after chance. And then she applies for sobriety court, the one program that could save her from jail. But here's where it gets ugly. She secretly starts working at a bar. A bar. With 4 DUIs on her record. She doesn't tell her probation officer. She doesn't tell the judge. And when she gets caught, the excuses start flying. I just helped out a couple times. I'm not fully employed. Sound familiar? The judge has heard it all before. And today, right here in this courtroom, he is about to explode. You're going to hear the exact moment this judge realizes he's been lied to. You're going to learn why working in a bar can turn a misdemeanor into 60 days in custody. And by the end, you'll be asking yourself one question. Did this mother deserve mercy, or did she bring this sentence on herself? Let's get into it.
I have 3 children that I'm trying to raise.
You're going to kill somebody. You're going to kill somebody. And I can't do this. I wish I could. The whole team agrees you need help. Summer Lori Greathouse, 25F245-336. All right. Your appearance, please, Mr. Lori. Name, your name.
All
right, so your client pled guilty to operating while visibly impaired back on March the 3rd of 26. She was referred for screening and assessment. At some point prior thereto, she violated the bond conditions on February 12th of 26. I issued a bench warrant, forfeited the bond, and set a new bond after finding that she had consumed alcohol. I told her at one point that she'd better get into sobriety court. If she did, I wasn't guaranteeing I wasn't guaranteeing anything, but that I guaranteed she was going to go to jail for a lengthy period of time if she didn't get into sobriety court. And that's where we are. If you had a chance to review the report, any material additions, corrections, or deletions.
Oh, yeah.
Anything that you would like to say on her behalf?
Your Honor, when you filed the pickup report, you thought that I wasn't you have talking about. Plan for sobriety. She had to determine anything that she lied. And she is no longer in denial that she has a alcohol substance abuse problem. In working, she's working hard as a realtor. She has 3 small kids. Applied with probation officer some minor flips. She had complied on the order.
Okay, anything else? Ma'am, anything you would like to say?
I am taking this seriously. I have been going to therapy on my own. I've been seeing a therapist now bi-weekly. I am going to IOP. I take that very seriously. My kids are my why. I am committed to this program. You would accept me.
You had a job interview at DTE, but you haven't heard anything yet? And you're working at LPT Realty, and that's the only place you're working.
I'm sorry?
Hold on. Did you catch that? The judge asks her where she's working, and she says LPT Realty is the only place. But watch her body language, "I'm sorry," comes out before the judge even finishes the question. That's a classic tell. In legal terms, this is what we call a lie of omission. She's technically telling the truth about real estate, but she's deliberately hiding something else. And here's why that matters in sobriety court. These programs are built entirely on voluntary truthfulness. The judge isn't a detective. He doesn't have time to investigate every claim. He relies on defendants to be upfront. The moment you hide something, anything, you've broken the contract. And this judge, he's been doing this long enough to smell a lie from across the bench. Let's see how long it takes him to start digging.
That's the only place you're working?
I have helped out a friend. She just opened up a restaurant. I've helped her a couple of times, but outside of that, no.
What restaurant?
JT's in Trenton.
Why didn't you tell your probation officer that before?
I'm sorry.
Why didn't you tell your probation officer that before? And why did I have to ask questions to find out that you were working at JT's?
I just helped them out a couple of times. I'm not like fully employed there. I want to be.
Okay.
Right there, stop. That single word tells you everything. The judge isn't asking anymore, he's confronting. And notice how he repeats her own excuse back at her. Why didn't you tell me that? He's not looking for an answer. He's making a point for the record. Because in this moment, he's realizing that she's been hiding a job at a place called JT's, which, based on the context we're about to hear, is almost certainly a bar. Now, here's the legal reality. Sobriety court participants can sometimes work in restaurants with special permission, but you have to ask first. You have to be upfront. She didn't do that. And when the judge asks, why did I have to find out by asking questions? That's the sound of trust evaporating. In this courtroom, trust is the only thing standing between her and a jail cell.
Why didn't you tell me that? You got 4 drunk drivings. You have no business working in a bar. And I don't mind telling you, if I had known in your situation, now I want you to understand, I've allowed people to work in bars and restaurants before that are in sobriety court, but these are under different circumstances. You had 4 drunk drivings. You had a 271. You violated your bond conditions. You've been working at JT's a lot more than a couple times. Don't tell me that. That is not truthful. I know too many people, young lady. I know too many people.
Whoa, this just got real. The judge just dropped a bombshell. I know too many people. Translation, he's already checked on her. Before she even walked into this courtroom, the judge likely had probation officers or court staff quietly verifying her story, and they found out she's been at JT's a lot more than a couple times. This is the moment the defendant realizes she's been caught. Notice the judge doesn't say, I think you're lying. He says, don't tell me that, and that is not truthful. Those are factual statements, not opinions. And here's the kicker. He even admits he's allowed other sobriety court participants to work in bars. So he's not being unreasonable. He's being consistent. The difference? Those other people were honest about it. She wasn't. In the judge's mind, that's not a mistake. That's a choice. And choices have consequences.
I know too many people. Don't tell me you've only worked there twice. You said a couple times you helped out a friend, and you didn't bother telling anybody your name. So I want to know, because you and I talked, because you had a conversation with her. I want to know, I want you to state for the record what she told you. And tell me when it was.
So the appointment was on April 20th. Found out in meeting with you on April 20th. That she was working at the bar. So at our appointment on Friday, that same April 24th, we had just been going over the screening. I asked if there were, anything new to add. We talked about employment and how she is supporting herself due to backing off real estate, and she said that she was supporting herself through her savings.
She didn't say anything about working at JT's.
No.
Your Honor, can I tell you why?
Yeah, you can tell me whatever you'd like, and I'd make it really good. I cannot have people in a sobriety court that are not being upfront and truthful with me. I can't do it. I won't do it. It's not, you have no chance. You had no business taking a position at a bar, serving as a bartender and a waitress. None. Particularly without coming to me and asking me if that was okay, or at least bringing it up with your probation officer, and you concealed it.
I didn't conceal it on purpose. Really? Let me translate that for you. That's what defendants say when they have no good answer. The judge just laid out the clearest possible standard. You must be upfront and truthful. You must ask permission before working in a bar. You must tell your probation officer about any job. She did none of those things. And now she's claiming it was an accident? Here's the reality check. In sobriety court, intent doesn't matter as much as behavior. Whether she meant to hide it or not, the result is the same: the court was misled. And the judge is furious because he put his own reputation on the line to recommend her for this program. He said earlier, "When I do this, I'm putting myself out there. That means if she fails, it reflects badly on him. She didn't just break the rules, she made the judge look foolish." And now, he's done being nice. Okay, let's pause and stack up the violations, because this is overwhelming. Number 1, she violated bond conditions by consuming alcohol that's already on the record. Number 2, she had 26 late blows on her breathalyzer.
I opened the place and asked her if I could pick up some shifts there to supplement my income because I'm not able to do real estate full-time right now. I'm not full-time employed. I would like to be. I really need the money to support my kids right now. I know the people that work there and I'm able to get rides from them, so yes, I have picked up shifts there. And I stopped asking to bartend. I was only picking up the serving shifts.
Listen. I have to go by my gut. I don't sense that you're taking this serious. You violated the bond conditions. You had 26 late blows. You tested positive on February 8, 9, 10, and 11 for alcohol. Like I said, you missed 26 blows or they were late.
In sobriety court, a late blow is often treated the same as a positive test because it avoids monitoring. Number 3, she tested positive for alcohol on February 8th, 9th, 10th, and 11th, 4 consecutive days of drinking while under court supervision. Number 4, she's not turning in her AA logs on time. Number 5, she concealed a job at a bar. And number 6, she lied about how many times she worked there. This isn't a slip-up. This is a pattern of non-compliance. The judge said earlier she needed to cross every T and dot every I. She did the opposite. And now he's about to drop the hammer. Let's hear the moment he makes his final decision. There it is. "I cannot take you." Those are the 4 words she didn't want to hear. The judge is officially rejecting her from sobriety court. And here's what that means in practical terms. Sobriety court is a voluntary intensive program that substitutes treatment for jail time. It's considered a privilege, not a right. By rejecting her, the judge is sending her back to the standard criminal track. And remember what he said earlier, her original charge was downgraded from what should have been a felony to a 9-3-day misdemeanor. That was her one break. But because she wasn't truthful, because she worked at a bar without permission, because she missed 26 breath tests, that break is gone. The judge even admits he feels bad. He says, "I wish I could take her." But the whole team agrees. She needs help she's not willing to accept honestly. And now, she's about to hear her sentence. Let me break down exactly what this sentence means.
When I do this, I'm putting myself out there. Okay? When I try to help people in felonies and this should have been a felony, like I told you, somebody dropped the ball in my view. I don't know why they didn't charge this as a felony. You got 4 of them. Grant, it goes back to 09, but you're only 38. You're only 38 years old. And you needed to cross every T and dot every I, and you didn't.
I have 3 children that I'm trying to raise.
You're going to kill somebody. You're going to kill somebody. And I can't do this. I wish I could. The whole team agrees you need help.
Because there's a lot here. First, Satodalov, 1, 310 inches financial penalties. Then the jail time, 61 days with credit for 1 served, so 60 days in custody starting immediately. She doesn't get to go home and pack. She doesn't get weekends. She doesn't get to start tomorrow because the judge specifically said no to that. And on top of it all, she faces an additional 30 days if she can't pay the fines and costs at $50 per week. That's a pay or stay provision. If she can't afford it, which is likely, given she's a single mom who just lost her real estate income, she serves 90 days total. The judge gave her 21 days to appeal and 14 days to apply for a public defender. But here's the reality. Appeals rarely succeed when the defendant admits to the core violation, working at a bar without disclosure. Okay, I want to hear from you. Put a 1 in the comments if you think this judge was absolutely right. She had 4 DUIs, she lied, she worked at a bar, she missed 26 breath tests, she needed to be held accountable. Put a 2 if you think 60 days is too harsh for a mother of 3 who was just trying to support her kids. And if you're somewhere in the middle, tell me what you would have done differently if...
Can't do it. I wish I could. I get so disappointed listening to people when I know that they're lying to me. This is not voluntary truthfulness on sobriety court in particular. There's no way I'm changing my mind, Mr. Longton.
Well, Your Honor, she was desperate because Henry family law case, he received no child support and had overseen no child support until baby June. If he'd been desperate for support, all of us usually she asked for surgery to get solved.
John, I have 3 kids. I'm going to take care of myself.
I get it. I get it.
I have been married to I get myself into therapy.
You also, listen, I want to take you. I want to take you. No. I cannot. I agree you need help. But I cannot do this. Ma'am, you should have thought about that before you got your first, second, third, and fourth drunk drivers. They should have charged a felon. You had a chance to keep this to a 93-day misdemeanor with a minimum jail term, and you were not truthful, and you went to work in a bar, which I can't even think of a worse place for you to be working. I'm sorry. 300 fines, 600 costs, 75 victims' rights fee, $50 justice assessment, $60 screening fee, $225 in cost of recovery, and 61 days. Credit 1, serve 60 now, and you're going to serve 30 more days if you don't pay your fines and costs. And I will let you pay those at the rate of $50 per week. And I will start that beginning on August what's the first Friday in August, Lisa? Amy?
Your Honor, could you possibly do this on weekends?
No. There's no way I can let her do it on weekends. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. You should have thought about all these.
August 7th, Judge.
August 7th. If you need more time, you call the court. We'll go on Zoom. I feel awful about this, probably as awful as you do, except I'm not the one serving the jail term. You're going to we'll let you make some calls, but you're in custody for 60 days. Yes, you are. And I'm not going to let you start tomorrow because you weren't honest with me. And when people aren't honest with me, this is what's going to happen, particularly with something that's as serious as going out and committing 4 drunk drivings. You have no idea how lucky you got that they didn't charge you with a felony. I'm sorry, ma'am. Have a seat. That's it. Sorry, guys. Haider Abdul Hussein Hassan, 26D827965.
You were the judge. Would you have given her one more chance? Would you have allowed weekends so she could see her children? Or do you think the judge's point about you're going to kill somebody overrides everything else? I read every single comment, so let me know what you think. One thing the judge kept coming back to is worth explaining in more detail. He said multiple times, this should have been a felony. Somebody dropped the ball. Here's what that means. In most states, a 4th DUI within a certain time period is automatically a felony, punishable by 1 to 5 years in state prison. But in this case, the prosecutor either didn't charge it as a felony or accepted a plea to a misdemeanor. The judge is furious about that because he believes the public is at risk. And here's the key legal principle. Even when prosecutors go easy, judges still have sentencing discretion. The judge could have given her the full 93-day misdemeanor sentence. He gave her 60 days plus the threat of 30 more. He actually went lighter than the maximum. That's his way of saying, I'm being reasonable, but you're still going to jail because you left me no choice. There's a heartbreaking contradiction in this case that I can't ignore. The defendant keeps saying her kids are her why, and I believe her. I think she loves her children. I think she's struggling. But here's the problem that the judge sees. If your kids are your why are you working in a bar? Why are you missing breath tests? Why are you testing positive for alcohol 4 days in a row? Why aren't you turning in AA logs? At a certain point, the judge stops seeing a struggling mom and starts seeing someone who is choosing alcohol over her family. That's the emotional gut punch of this hearing. The judge isn't angry because she's poor or because she made a mistake. He's angry because she had every opportunity to be honest and she wasn't. And when the person asking for mercy can't even tell the truth about where they work, how can the court trust them with anything else? So where does this leave us? The defendant is in custody as of today. She has 21 days to decide whether to appeal. She has 14 days to request a lawyer, and she has a very difficult conversation ahead with her 3 children about why mommy won't be home for the next 2 months. But beyond this one case, this hearing teaches us something bigger about sobriety court and the criminal justice system. It shows that judges have enormous discretion and that honesty isn't just a nice to have, it's the entire foundation. If you lie, if you hide, if you think you can work a bar job without permission and no one will find out you are wrong, this judge proved that he does know too many people. And now, let's bring it all together with a final professional summary. This case involved a 8-year-old mother of 3 with 4 prior drunk driving convictions, the most recent resulting in a guilty plea for operating while visibly impaired. The defendant applied for sobriety court, a voluntary, intensive treatment program designed to replace jail time with structured accountability. However, the court discovered that she had violated bond conditions by consuming alcohol, missed or was late for 26 breathalyzer tests, tested positive for alcohol on 4 consecutive days in February, failed to submit AA logs on time, and most critically, concealed that she was working at a bar called JT's while under court supervision. The judge, citing a lack of voluntary truthfulness and an unacceptable risk to public safety, rejected her from sobriety court and imposed a sentence of 60 days in immediate custody plus 1,310 ein fine sand fees, with an additional 30 days ifs Heffail pay 50 per week. The judge noted that the case should have been charged as a felony and that the defendant received significant leniency already. The broader implication is clear. Sobriety court is a privilege, not a right, and dishonesty, especially when it involves working at a bar with multiple DUIs, will result in immediate incarceration. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, tell me if you think 60 days was justice or cruelty, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We release new legal deep dives every week, and you won't want to miss what's coming next. Subscribe now, and I'll see you in the next video.